Section 39 Transfer of Property Act. Section 39 Transfer where third person is entitled to maintenance. Transfer, it talks about situation, talks about transfer where third person is entitled to maintenance. ऐसे ट्रांसफर जहाँ पर प्रॉपर्टी में थर्ड पर्सन को मेंटेनेंस के प्रोविजंस नियुक्त किए गए हों. Where a third person has a right. Here third person means the one who is not a party to the contract. A has transferred property to B. A and B, they are first and second party, and anyone having interest in the property is termed as third person. अगर A ने B को प्रॉपर्टी सेल की है तो A और B है कॉन्ट्रैक्ट में पार्टी, और जिस अगर अलग व्यक्ति का प्रॉपर्टी में कुछ इंटरेस्ट है वो होगा थर्ड पर्सन. नाउ दिस थर्ड पर्सन हैज अ राइट टू रिसीव maintenance or a provision for advancement or provision for marriage from the profit of immovable property. Okay, so third person Mr. C has right to receive maintenance or provision for advancement or provision for marriage is there from the profits of the immovable property. And this immovable property, such property is transferred means this immovable property out of which he is having right to maintenance and other provisions, it is transferred. Now such right may be enforced against transferee. So these right to receive maintenance, now A has transferred the property to B and C is the third person. Now C can enforce these right against transferee. He will ask B, who is transferee, to divert this amount to him. Now what are the conditions? Conditions are, if he means transferee. If transferee has notice that yes, there is certain maintenance or provision has been made with the property, or if transfer is gratuitous, if it is gratuitous meaning thereby no consideration is there, in this case this right may be enforced against transferee. C can get the right implemented, get the right enforced against B, transferee, but not against a transferee for consideration and without notice. So if transferee has no consideration, or transferee has no notice, then it cannot be enforced against him. Okay, but not against a transferee for consideration and without notice of the right, nor against such property in his hands, meaning thereby now he cannot claim maintenance, the property which is there available with the transferee. But if transferee has notice or transfer was gratuitous, then he is liable. तो C यहाँ पर क्लेम कर सकता है अगर B जो कि ट्रांसफरी है उसको नोटिस था या ट्रांसफर ग्रेटिट्यूस था, तो ट्रांसफरी के अगेंस्ट C राइट को एनफोर्स करवा सकता है. लेकिन अगर ट्रांसफरी ने कंसिडरेशन पे किया है और उसको नोटिस नहीं है तो वो नहीं करवा सकता. नोर अगेंस्ट सच प्रॉपर्टी इन हिज हैंड्स, मीनिंग देयर बाय इन द प्रॉपर्टी विच ट्रांसफर इज हैविंग he is not bound to pay. For example, A is a father, leaves the property to his son S. Okay, he leaves the property to his son S and then made a provision in transfer that he means son would pay D, daughter of A and sister of B. So this son will pay certain amount out of this property. Leaves property meaning thereby he has given this property by will, by succession, by whatever mode he has given this property to S and then put a clause. Then S transferred, son transferred the property to X. Now X is transferee, son is transferor and sister is third party. So X had notice of provision of maintenance. Now D can get it enforced against X, the same condition which we talked in the section. And S, this is the case second, S transferred the property to X. This transfer was gratuitous. Now irrespective of fact whether X had notice or not, D can get it enforced. Now third condition, X did not have notice of provision of maintenance and transfer was for consideration. D cannot get it enforced against X. Now in case of property through succession, there may be viable variation being having vested interest or similar other thing of the other members. Now these vested interests are different from interest created. For example, interest of maintenance and provisions. These are interest created by one person in favor of other. Now this section does not talk about charge, which is mentioned under section 100. Charge on property and provisions made through transfer and will, they are different from this section. It does not deal with. Now let us see a case. Sadhu Singh versus Gurdwara Sahib. What happened in this case? A transferred his self-acquired property through will to his wife W. Then A provided that W would be having life interest, that is limited estate. Life interest is also used synonymally with limited estate in the property. Okay, and after life of W, property will go to P, nephew of A. However, W during her lifetime gifted the property to Gurdwara. Now on death of W, P claimed property from D. A ने अपनी सेल्फ एक्वायर्ड प्रॉपर्टी अपनी वाइफ W को ट्रांसफर कर दी विल के थ्रू, और विल में प्रोविजन बनाया कि जो वाइफ है W है उसका सिर्फ लाइफ इंटरेस्ट होगा, लिमिटेड एस्टेट मिलेगी. लाइफ इंटरेस्ट मीन्स शी इज नॉट द एब्सोल्यूट ओनर, शी विल हैव द प्रॉपर्टी टिल लाइफ. जब तक वो जिंदा है तब तक प्रॉपर्टी उसके पास रहेगी, और उसके बाद प्रॉपर्टी P को चली जाएगी जो कि उसका नेफ्यू है. लेकिन यहाँ पर जो W थी उन्होंने अपने जीवन काल में ही प्रॉपर्टी गुरुद्वारे को गिफ्ट कर दी, गिफ्ट डीड कर दी. नाउ जब W की डेथ हुई, उनकी मृत्यु हुई, वो परलोक सिधार गई, तब B ने अपनी प्रॉपर्टी को D यानी गुरुद्वारे से क्लेम किया. Here Gurdwara is D, and in this case Gurdwara is defendant also. Where it has gone? Here. Gurdwara D. Now issue was alienation of property by W was valid or not, and section 14 of Hindu Succession Act provides that wife to have absolute interest and hence she can alienate the property. But 14.2 provides that if it is limited estate, wife is bound by the same. तो क्या ये एलिनिएशन वैलिड है या नहीं है? और सेक्शन 14 है जो हिंदू सक्सेशन एक्ट का, वो कहता है कि वाइफ के पास एब्सोल्यूट इंटरेस्ट होगा, लेकिन 42 कहता है कि अगर लिमिटेड एस्टेट है तो वो उस लिमिटेड एस्टेट से ही बाउंड होगी. अभी 14 और 1 और 2 का देखते हैं हम कि क्या प्रोविजन है, वो भी बताएंगे इसके साथ ही. नाउ कोर्ट ने कहा, ट्रायल कोर्ट डिक्रीड इन फेवर ऑफ पी दैट यस P nephew, he will get the property. Okay. High Court reversed and matter is to Supreme Court. High Court reversed the judgment, matter is to Supreme Court. Supreme Court said that 14.1 provides for absolute interest, but 14.2 provide for restriction to be applicable. Now, since through will A has put restriction, then by virtue of 14 clause 2, it will prevail. If you will see the language of Bare Act of Hindu Succession Act, Section 14 of Hindu Succession Act, it talks about any property possessed by a female Hindu, whether acquired before or after commencement of this act, shall be held by her as full owner and not as limited owner. Fine. But 14 clause 2 says, nothing contained in subsection 1 shall apply to any property acquired by way of gift. Now acquisition is happening by way of gift or under a will or any other instrument or under decree or order of civil court or an award where terms of gift, will or other instrument or decree, order, reward prescribed are restricted estate in such property. So these are the modes, that if it is property is being given by gift or by will or any other instrument, or court has award property by such instrument, then nothing contained in subsection 1 will apply. So here when property is acquired, self-acquired property is acquired through will, then 14 clause 2 will prevail. Hence, she will be having a life interest and not the absolute interest. Then section 28 of Hindu Adoption and Maintenance Act is perimetry with section 39 TPA. Now Supreme Court decreed in favor of P, and Gurdwara D was asked to give property back to P, and this transfer was held to be null and void. And Supreme Court also noted that W, wife, might have secured maintenance from such property, however wife died during the pendency of the case. Now it takes you to where third person is having interest. Apart from that, section 28 of Hama also allows to have maintenance. Now here third person is having interest. You can, if you consider W as third person, and transfer is valid. Section 28 of Hama Hindu Adoption and Maintenance Act talks about effect of transfer of property on right to maintenance. Now it has similar language with that of section 39. It says where a dependent has a right to receive maintenance out of an estate, okay, and such estate or any part is transferred, then right to receive maintenance may be enforced against transferee if transferee had notice to the right, or if transfer is gratuitous, but not against transferee for consideration without notice of the right. Similar language, almost same language is there in section 39, which we are studying now. Then let's see another case. What happened in this case? Facts are: W, wife, she put a suit to maintenance against H, husband. Now court decreed the suit in favor of wife and granted maintenance to wife. Later H, husband, sold the property to D. Now wife claimed maintenance from D. वाइफ डब्ल्यू ने केस किया हस्बैंड के ऊपर मेंटेनेंस के रिगार्डिंग, कोर्ट ने वाइफ को मेंटेनेंस दिलवा दी. उसके बाद जो हस्बैंड था उसने प्रॉपर्टी सेल कर दी डी को, और वाइफ ने फिर मेंटेनेंस क्लेम किया. तो क्वेश्चन इशू था कि क्या वाइफ के पास राइट टू मेंटेनेंस है या नहीं है, वो एनफोर्स करवा सकती है या नहीं. कोर्ट सेड that third person can get right to receive maintenance from transferee, and then again 39 and 28 similar commentary like in the previous case. And court also said that since charge was created on property, section 100 TPA talks of two parties, but section 39 allows third party. So 39 and 100 are different, and 100 will not apply here. So even if party contests that charge has been created, it is the nature of charge, but section 100 will have no application because it talks about two party, and here third party is allowed. Section 100, where immovable property of one person is by act of parties or operation of law made security for the payment of money to another. So immovable property of one person by act of parties or by operation of law, इसको क्या किया गया है, इसको सिक्योरिटी बनाया गया है पेमेंट ऑफ मनी टू अनदर. दूसरे व्यक्ति को जो पेमेंट होगी उसकी सिक्योरिटी इस इमूवेबल प्रॉपर्टी के थ्रू अटैच की गई है. सो वेयर इमूवेबल प्रॉपर्टी ऑफ वन पर्सन इज बाय एक्ट ऑफ पार्टीज और ऑपरेशन ऑफ लॉ हैज बीन मेड सिक्योरिटी फॉर पेमेंट ऑफ मनी टू अनदर नाउ, एंड द ट्रांजैक्शन डज नॉट अमाउंट टू अ mortgage. The later person, transferee, is said to have a charge on the property. The later person who has this payment secured will be having charge on the property. We'll deal when we reach there. For the purpose of this section it is sufficient. Section 39, if any question query is there, you can put that in comment box.